Welcome to the Lion's Share podcast, where we break down today's most impactful research and bring fresh insights from the academic frontier straight to you.
If you're involved in finance or corporate law, you've definitely heard about this clash, right? US GAAP, the rules-based system, versus IFRS, the more principles-based approach that much of the world uses.
Oh, absolutely. It's been a huge debate for decades. And it's not just, accountants arguing over definitions. It's got massive implications for corporate risk, particularly legal risk.
Exactly. The SEC looked really seriously at switching the U.S. over to IFRS for years. And the big worry, the thing everyone kept coming back to, was litigation. What happens if we ditch the specific rules?
Does it just open the door for more lawsuits? That's the core question. And today, we're diving deep into a paper that tackled this head-on. Donelson, Mclnnis, and Mergenthaler's 2012 study, Rules-Based Accounting Standards and Litigation.
Right. Our mission here is to unpack how their research, using actual data, try to answer this really high-stakes policy question, moving beyond just theory.
And let's give you the headline finding up front. They found that more rules-based standards were actually linked to fewer securities lawsuits being filed.
Fewer lawsuits? That's pretty counterintuitive for some, maybe.
It can seem that way. The idea is that the rules, even complex ones, act as a kind of shield. So if you're managing a company, this paper suggests that complexity you might complain about, it could actually be protecting you legally.
That finding is incredibly relevant for practitioners, for you listening.
Yeah.
It really frames accounting standards not just as a compliance task, but as a strategic choice impacting legal exposure. It gave managers some real data points.
Definitely. Okay, so before we get into the weeds, let's define some key terms they use. First off, how did they even measure rules-based?
Good question. They created something called the Rules-Based Continuum Score, or RBC score. It's basically a scale from 0 to 4.
0 meaning very principles-based, 4 meaning very rules-based.
Exactly.
Yeah.
And they've scored standards based on 4 things. Does it have bright line tests, specific numerical thresholds? Does it have lots of scope exceptions or special rules for certain situations?
Like legacy exceptions, yeah.
Right. Is it super detailed? And does it come with tons of implementation guidance? The more yes answers, the higher the RBC score.
Okay, so they have this measure. Now, why would a high or low score matter in court? That brings us to the two main theories they were testing. First is the protection theory.
This one argues that rules protect companies. 2 main ways. First, a safe harbor. If you followed the specific rule to the letter, it's hard for plaintiffs to argue you used bad judgment.
Makes sense.
Second, the innocent misstatement defense. If you do make a mistake and have to restate your financials, you can argue, look, these rules are incredibly complex. It was an honest error, not fraud.
Okay, so that's the protection argument. What's the counter argument?
That's the roadmap theory. This view says, actually, those specific rules give plaintiffs a clear roadmap to sue you successfully.
How so?
Because if the rule is really specific and objective and you clearly didn't follow it, it makes it easier for plaintiffs to argue you intended to mislead or were at least reckless about it.
Ah, okay. It makes proving intent or scienter potentially easier for the plaintiffs.
Precisely. And scienter is absolutely critical in U.S. securities litigation, especially after the Private Securities Litigation Reform Act of 1995, the PSLRA.
Right. The PSLRA really raised the bar for plaintiffs. You have to plead facts showing strong evidence of scienter, that fraudulent intent or recklessness right up front in the complaint. You typically don't get discovery, access to internal documents until after your case survives a motion to dismiss.
So if a standard is vague and based on judgment, proving that scienter up front is much harder than if there's a clear rule that was violated.
Okay, that context is crucial. So, with that set up, let's jump into our structured questions about the paper. First one, what exactly was the research question and why was it so important at the time?
Simply put, they wanted to know, does how rules-based an accounting standard is affect whether companies get sued in securities class actions? And does it affect how those lawsuits turn out, like whether they settle or get dismissed?
And the importance, as we touched on, was all about policy. The SEC was actively considering this major shift towards IFRS, towards principles. But there was a lot of talk, a lot of maybe rhetoric, but not much hard data on the litigation consequences.
Right. People like Karen Schipper back in 2003 were basically saying, we need real evidence here. Policymakers needed to know if complex rules helped or hurt when it came to lawsuits. This paper aimed to provide that evidence.
Okay, so they're tackling this big policy question. Next, what theories did they use to build their specific hypotheses?
They set up predictions based on that clash between the protection and roadmap theories, but applied them differently depending on the situation. Let's take the first situation, non-restatement cases.
So these are lawsuits where someone alleges a GAAP violation, but the company hasn't actually admitted one by restating.
Correct. For these cases, their hypothesis 1, H1, was really driven just by the protection theory's safe harbor idea. Meaning, if you're a plaintiff's lawyer and you don't have discovery yet because of the PSLRA, attacking a company for violating a complex, specific rule is really hard. How do you prove they didn't follow it without internal info?
Right. It's much easier to attack a judgment call made under a more principles-based standard.
Exactly. So H1 predicted that plaintiffs would tend to avoid suing over standards with high RBC scores in these non-restatement situations. They'd pick the easier, more judgment-based targets.
Okay, that makes sense for H1. What about restatement cases where the company has admitted an error?
Now it gets interesting because protection and roadmap theories predict opposite things. Roadmap says the clear rule violation makes suing easier. Protection says the complexity provides a defense.
So which way did they lean for hypothesis 2, H2, which looked at the incidence or likelihood of being sued after a restatement?
They hypothesized H2 based on the protection theory, predicting a negative relationship. They thought that even with an admitted error, higher rules-based scores, more complexity, would decrease the chance of getting sued.
And the logic there is the innocent misstatement defense.
Exactly. The argument that this standard was so complex, it was an understandable error, not fraud. They pointed to U.S. case law, like the INRI MicroStrategy case, suggesting courts sometimes buy this argument that complexity can weaken the inference of scienter needed under the PSLRA.
Okay. And hypothesis 3, H3, looked at the outcome of those restatement lawsuits that did get filed, right?
Yes. H3 predicted that the same innocent misstatement defense would also lead to better outcomes for companies sued over high RBC standards. So a lower chance of the lawsuit surviving dismissal, or maybe lower settlement amounts. Again, a negative prediction for plaintiffs.
Got it. So H1 and H2 predict rules protect firms from getting sued. H3 predicts rules help firms if they do get sued.
That's the setup. Now let's get into the rigor. How did their research design tackle tricky issues like validity, non-random selection, and endogeneity? This is where the quality really shows.
Absolutely. First, construct validity. Did their RBC score actually measure rules-basedness? They did several checks. The 4 components of the score correlated well with each other. Standards the SEC itself had flagged as rules-based, like the infamous SFAS 13 on leases, got high RBC scores, a full 4 in that case. And importantly, they showed U.S. GAAP standards consistently scored higher on the RBC scale than the equivalent IFRS standards.
Okay, so the measure seems solid. What about internal validity, especially for H1, the non-restatement cases?
Here they used a really clever design. Each firm effectively served as its own control. They compared the RBC score of the standard the plaintiff claimed was violated against the average RBC score of all the significant accounting policies the company listed in its 10K filing around that time.
So they're comparing the standard chosen by the plaintiff to a whole menu of standards the plaintiff could have easily targeted from the company's own disclosures. That's tight.
Yeah. Very tight. Now, for H2 and H3, the restatement cases, they face the non-random assignment problem. Companies that restate and get sued are likely different from those that restate and don't.
How they handle that?
They created a careful control group. They took their 189 sued restatement firms and matched them against 84 firms that also had material restatements defined as causing at least a $50 million market value drop, but were not sued.
So the control group firms were just as tempting targets in terms of the financial damage caused, but somehow avoided litigation.
Precisely. It helps isolate the effect of the standard itself rather than just, say, the size of the restatement.
Okay, well, what about the elephant in the room for accounting research? Endogeneity. Rules-based standards often apply to really complex transactions. Was it the rule-protecting firms or just the sheer difficulty of suing over something inherently complicated like derivatives?
Great question, and they tackled it directly. They ran robustness checks controlling for transaction complexity. They used proxies, like literally whether the word complex appeared in the standards text, or even the log of the length of the definition of the transaction in the standard.
Okay, so trying to measure the complexity of the underlying economics.
Exactly. And they found that even after controlling for these complexity proxies, the negative relationship between the RBC score, the rules characteristics, and the likelihood of being sued held up.
And importantly,
the economic impact of the RBC score itself was often larger than the impact of the transaction complexity controls. This strongly suggests it's something about the nature of the rule, its specificity, its bright lines, that's driving the result, not just the complexity of the deal itself.
that's a critical finding for their argument. Okay, that leads us to the methods. What specific econometric techniques did they use, and how did those choices help strengthen the analysis?
Well, for H1, that own firm control design was simple but powerful, so they could use basic univariate tests comparing mean and median RBC scores between the allegedly violated standards and the firm's other policies. T-tests, Z-tests, pretty standard stuff there.
But for H2 and H3, looking at sued versus not sued, or dismissed versus settled, they need something more, right?
Right. Those are binary outcomes, yes, no. So they primarily use logistic regression, or logit models. For the settlement amount, which is a continuous variable, they use standard OLS regression.
And the logit models are where they could really load in those control variables we talked about.
Exactly. The logit models allowed them to control for those 11 different factors that prior research showed could influence litigation risk, things like firm size, market to book, stock volatility, insider sales, the sheer size of the potential damages.
So trying to statistically account for all those other reasons a firm might get sued to isolate the effect of the RBC score.
Precisely. It helps mitigate that non-random assignment bias we mentioned earlier.
Did they do any other checks to make sure the results weren't just picking up, say, a difference between outright fraud and simple errors?
They did. They ran tests splitting the restatement lawsuits into cases that settled where you might infer a higher likelihood of actual fraud, and cases that were dismissed, which might be more likely to be errors.
And
the negative relationship between the RBC score and the likelihood of being sued held up in both groups. They even looked at a sample of firms investigated by the SEC for accounting issues, and again found that those investigated over more rules-based standards were less likely to also face private litigation. It consistently points towards rules being protective.
Okay, really building confidence in that core finding. So let's summarize. What were the major results, and did they effectively answer the research question?
Yes, they provided pretty clear answers. For H1, strong support. In those non-restatement cases, the standards plaintiffs alleged were violated had significantly lower RBC scores, average 0.87, compared to the average score of all the firm's significant policies, average 1.73.
So plaintiffs were indeed avoiding the highly rules-based standards when there wasn't an admitted restatement. Supports the safe harbor idea.
Exactly. For H2, also strong support, crucially for the protection theory over the roadmap theory. The RBC score was strongly negatively related to the probability of being sued after a restartment. The T statistic was negative 5.73, highly significant.
And you mentioned the economic impact earlier.
Yeah, a 1-unit increase in the RBC score, say, going from moderately rules-based to highly rules-based, decreased the odds of litigation by about 12.1 percentage points. That's a substantial protective effect, supporting that innocent misstatement defense argument.
Okay, H1 and H2 support protection. What about H3? The outcomes. Did rules help companies win or settle for less if they were sued?
Here, the results were null. They found no significant link between the RBC score and whether a lawsuit survived dismissal or the size of the settlement if it did settle.
So the rules protect you from getting sued, but once you are sued, they don't seem to help much in the outcome. How did they explain that?
Their explanation, which seems very plausible, is a screening effect by plaintiffs' attorneys.
Meaning,
lawyers who bring these cases are sophisticated. They know that winning a case based on a violation of a highly complex, rules-based standard is tough unless the violation is really egregious. So they likely screen out the weaker rules-based cases before filing.
So only the really strong cases involving high RBC standards even make it to court?
Plausibly, yes. By the time you get to the outcome stage, dismissal motions, settlement talks, the cases that remain are probably strong regardless of the standard type. The initial filing decision, influenced by the RBC score, has already weeded out the weaker ones.
That makes a lot of sense.
Okay.
Final question on the paper itself. What were the main conclusions, and do you think they were justified based on the theory, design, and results?
Their main conclusion is straightforward. Rules-based accounting standards decrease the threat and incidence of securities class action litigation. The evidence strongly supports the protection theory, particularly its safe harbor and innocent misstatement components.
And is that conclusion warranted?
I'd say yes, very much so. The robustness of the H2, finding that negative link between RBC and getting sued across different samples, controlling for complexity, controlling for numerous other factors, it's compelling archival evidence.
So what's the big policy insight here?
The big insight is that the structure of accounting standards isn't just a technical issue, it's deeply intertwined with the legal environment. In the U.S., with the high scienter bar set by the PSLRA, the complexity and specificity of GAAP rules seem to have become a functional defense mechanism for corporations.
It really connects the dots, doesn't it? Accounting standard setting isn't happening in a vacuum. It's shaped by and shapes litigation risk.
Absolutely. And it directly challenges that earlier SEC thinking or hope that moving to principles-based IFRS might actually reduce litigation. This paper's evidence points the other way.
Right. It suggests a shift away from rules could weaken the shields firms currently have, potentially increasing litigation, at least in the U.S. system.
Which leaves us with a really provocative thought for you, the listener, especially if you're in practice or policy. If the U.S. were to adopt more principles-based standards, relying more heavily on management judgment.
And assuming this paper is right, that litigation risk would likely increase.
How much confidence should we have that the existing legal framework, particularly the PSLRA's high-intent standard, would be enough to prevent a surge in lawsuits challenging those judgments?
That's the critical uncertainty, isn't it? How would the legal system adapt to judging intent when the underlying standards are less about bright lines and more about broad principles? That's a huge question.
It really is. It highlights the delicate balance between accounting standards, legal frameworks, and corporate behavior.
A fascinating paper with some really significant practical implications. Thanks for unpacking that with us.
My pleasure. It's a great example of rigorous research informing a major policy debate.
Indeed. And thank you for joining us on The Deep Dive. We'll see you next time.
Thanks for tuning into the Lion's Share podcast. If you enjoyed today's discussion, share it with a friend and join us next time for more ideas worth talking about. We'll see you next time.